Hello, we are Group 7 and this is our presentation on the regulation of maritime autonomous surface ships. We will be looking at the United Convention of the Law of the Sea, which is intended to achieve a mutual understanding amongst states relating to the law of the sea. We will be focusing in particular on Article 94, which outlines the duties of the flag states. We will also analyse the International Convention for the Safety of Life at Sea, which was intended to establish the least safety measures in the construction, equipment and operation of merchant ships. Here we will be focusing on Regulation 14 of Chapter 5, which relates to the manning of the ship. Both of these pieces of legislation were made some time ago and therefore were not made with autonomous ships in mind. We will be considering the extent to which the relevant sections are compatible with MASS and therefore whether they pose a barrier. In considering how compatible the legislation is to MASS, throughout the presentation we will be ranking the relevant legislation with a traffic light system, of green being the least problematic and red signifying legislation which poses the most significant barrier. Before analysing the regulation in detail, it is first important to consider what we mean by maritime autonomous surface ships, or MASS. They have been defined as ships which to a varying degree can operate independent of human interaction. The use of the term varying degree tells us that there are different levels of autonomy. Various sources have sought to define these levels, but we will be referring to the Lloyd's Register, which starts at level 0 with no autonomy and goes to level 5 where onboard override isn't even a possibility. Legislation may apply differently depending on the level of autonomy, which we will highlight throughout the presentation.
First, we shall consider whether a maritime autonomous surface ship would actually satisfy the definition of ship. If it does not, this would be a fundamental barrier, as UNCLOS and SOLAS would not apply, which would essentially make this whole presentation invalid. As we can see, UNCLOS details ship here in Article 94.1. However, a significant issue is that UNCLOS does not define ship, and this combines with a point raised by Veal et al. That is, that no internationally uniform legal definition of ship exists, and instead it is up to the decision of the flag state, which would make it difficult to say with certainty if MASS will satisfy the definition in every circumstance. What is evident, however, is that it would likely satisfy in the UK. This is because it is defined in the Harbours Act 1964 as every vessel used in navigation, seaplanes on the surface of water. Although international regulation does not appear to contain any direct requirements for ship to be manned in order for it to be considered a ship, the issue arises with other nationalities' regulations. Take, for example, the definition of ship in French law defined in the Code of Transport 2010, which details a boat must be manned for maritime merchant navigation. This would be problematic for higher level autonomy ships which may not be manned. Nevertheless, we have given this barrier a colour green to suggest that while it is problematic, this issue may not be fundamental as other barriers. This is because although UNCLOS alone does not provide a definition, this opens the floor to international interpretation, which could include autonomous ships, and for the UK this does not appear to be an issue.
Article 94.3a requires states to take measures to ensure safety as it pertains to the construction of ships. Now, manufacturers of conventional ships follow international standards when they construct those ships, such as the standards found in the annex chapters of SOLAS. But unmanned maritime vehicles that are too light or that are not engaged in international voyages will not come under some or all of those standards, and resultantly, Veal and others have said, operators have no certification benchmark to guard them against civil liability. Now, this may act as a practical barrier or have a chilling effect because without international standards to follow when constructing MASS, manufacturers won't know if they've constructed them well enough to avoid liability. However, Ling Zhu suggests that regulators and states are working on producing guidelines, so this problem may quickly be resolved.
Seaworthiness is also mentioned in section 94.3a of UNCLOS. Could this easily be applied to MASS vessels? There is no explicit definition of the term within UNCLOS, however we can look to domestic legislation and maritime case law for clarity. In the Good Friend, seaworthiness included the ship's ability to deliver cargo at the specified destination, not particularly contentious. However, what if there is a software malfunction or cyber breach on an AL5 MASS vessel? It may then be unable to deliver goods and yet still be in seaworthy condition, at least in regard to physical construction, which Charlie discussed. George Walker recommends that courts look to the Maritime Insurance Act when considering seaworthiness under UNCLOS. Here, a traditional vessel was seaworthy when she is reasonably fit in all respects to encounter the ordinary perils of the seas. However, there are unique perils facing mass, namely cyber breaches and consequent malfunctions. They may become ordinary perils for fully autonomous ships, and a wider reading of the phrase "of the sea" will have to be taken, as hacking may be done remotely, even entirely on land. Lastly, although not an UNCLOS, something important to consider is the criteria in Papera Traders, which mentions the adequacy of the crew, their competency and training. This raises eyebrows, especially if the ship was at level AL5. Who is the crew now? The software, the people at the ship base monitoring the ship, and how would their competency be measured? By ensuring the latest software update has occurred? Courts will need to take into consideration technological developments in the wording of future judgments, or else there will be a real barrier here if the wide reading of seaworthiness isn't taken in future. Barrier level amber.
Article 94.3 also outlines the importance of using signals, maintaining communications and preventing collisions to ensure safety. This raises questions for mass, namely how can safety truly be ensured with no human monitoring the ship? The software will evidently have to be of a very high standard to comply with these requirements, but statistics suggest that 75 to 96% of marine accidents are caused in some part by human error, making it likely that mass will actually be more effective at preventing collisions. Furthermore, whilst there may be no human directly monitoring the ship in higher levels of autonomy, data from the ship would still be processed in order to ensure that these provisions are being met. Maintenance of communications is also paramount, particularly in lower levels of autonomy, where human intervention is still required, but may be done so remotely, as communication must be of a high enough standard to allow this interaction between the ship and the human. Measures necessary to ensure safety in this regard may require the software to be able to effectively take over control of the ship should communications fail, which clearly holds mass to a high threshold, as this safeguard would not be required in conventional ships. Given the risks involved with hacking autonomous ships, mass may also be required to have safeguards in place so that humans can monitor the ship and intervene to prevent collisions in these circumstances. This may be a problem for AL5, where onboard override is not possible.
Section 94.4a of UNCLOS requires a qualified surveyor to check the ship before and during a voyage. Yet how could this be done for mass at sea? Cameras could be operated remotely by humans to survey the vessel, or autonomous technology on board mass could identify and report back issues even more quickly by utilising AI. These sections are fundamentally concerned with ensuring the ship can navigate safely and has the appropriate tools to do so, but clearly had traditional physical tools in mind, such as a compass and sextant. However, modern technological equipment is a more precise, safer substitute, and there is no reason as to why this new equipment cannot be said to be on board if it just so happens to be integrated within the vessel itself. Finally, in the above section of SOLAS, a minimum safe manning document or equivalent is required. This may have traditionally referred to a physical piece of paper, but this would likely be virtual now, perhaps incorporated in scannable QR code form on part of the vessel. Manning documents give information about the vessel's port of registry, IMO number, and specify the minimum number of crew members on board. It seems unlikely that the traditional meaning of crew member can be stretched to mean a robust centralised computer system. However, is this even necessary? Surely the document can simply state there is no need to have a crew member on board in the traditional sense to ensure safe navigation. The AI can confidently ensure this alone. Hence why this section only presents a green barrier. Once the technicalities of the wording are skimmed over, it seems quite compatible with mass. However, other sections do explicitly mention more human-like qualities to the actual acts of manning, and it is these contentious sections that will be discussed in further detail.
One of the most significant barriers to mass is the issue of manning, and in particular the manning of officers and masters. First, we shall discuss this in relation to UNCLOS. Manning is referred to in Article 94.3, but the specifics are laid out in 94.4, as shown here. It is important to note that the issues concerned with manning requirements will impact mass differently depending on their level of autonomy. Lower levels such as AL1 or 2 would still require crew, and so would not be impacted in the same way as AL5, where according to Lloyd's Register, masters have no ability to override the technology, and therefore it is safe to assume there could be no crew. For the purposes of this argument, I shall refer to high-level masses. Firstly, concerning the manning of crew, Article 94.4 details crew must be appropriate in numbers needed for that type of ship. One could therefore argue that where there is an autonomous ship that does not require crew, this would be satisfied, as it would be appropriate for the type of ship. This is supported by Laft et al., who highlight that there is no indication that crew is an essential element of a ship. However, the issue of manning a master is not so straightforward. Article 94.4 details that a ship must be in the charge of a master. The Merchant Shipping Act 1995, section 313, defines master as every person having command of a ship. According to Veal et al., a remote operator would have the command, and therefore this should be satisfied with a remote master, as they would still have command, albeit remotely, of the ship. However, AL5 autonomous ships may not require remote masters at all, and therefore it is difficult to see how Article 94.4 could be applicable here. Technology alone could not qualify as a person having command, nor an individual who possesses appropriate qualifications. As highlighted by IMO in the context of unmanned ships, it is also difficult to see a way forward with regard to autonomous ships without an overall review of the scope of the term of master. This is why we view this barrier as fundamental and have ranked it with red in accordance.
Regulation 14 of Chapter 5 of SOLAS focuses entirely on the topic of manning, requiring that all ships are sufficiently and efficiently manned. Accordingly, it presents some of the same problems as UNCLOS 94.4b, but it lacks UNCLOS's requirement for a master. Regulation 14 directs states to the IMO Resolution on Principles of Safe Manning. Voshkovic and Milenkovic say that this is what the Maritime and Coast Guard Agency of the UK considers when evaluating safe manning levels. Some of these principles are easily satisfied by MAS, such as the ability to moor and unmoor safely, or ensure safe carriage of cargo during transit. Some of the principles will be difficult for MAS with no crew to satisfy, such as the ability to deploy a competent damage control party when there is a problem with one of the ship's watertight closing arrangements, or the ability to maintain the main propulsion and other machinery. It would presumably be difficult for MAS to carry out ad hoc repairs without crew on board. However, the guidelines for the application of the principles do acknowledge that states should take into account all relevant factors, including the type of ship, the equipment of the ship, and the method of maintenance used. So, to the extent that Regulation 14 acts as a barrier to MAS, these guidelines may come to the rescue. If you have a highly advanced ship with highly advanced equipment and some method of self-maintenance, these are very relevant factors that may satisfy regulators that even a crew of 0 is safe. Paragraph 5 of Article 94 says that when taking the UNCLOS measures that we have discussed in this report, each state must conform to the generally accepted international regulations, procedures, and practices. Maybe this provision would allow MAS to be in compliance with Article 94, so long as other international regulations, procedures, and practices are or become sufficiently welcoming of MAS. Ringbaum argues that if the IMO endorses the development of new shipping technologies, even to the point of totally unmanned or AL5 ships, then UNCLOS itself is not a barrier to the introduction of such technologies, thanks to Article 94, Paragraph 5. He says that some tension with the wording of Paragraph 4 doesn't preclude the IMO from regulating the question of MAS. Ling Zhu agrees, saying that if the IMO wants to regulate MAS, the manning and other obligations under UNCLOS are not a big concern. So it seems that the existence of this paragraph will probably go some way to preventing the other provisions in Article 94 from being a true barrier to the introduction of MAS.
As the quote here highlights, there is a real risk that the current legal frameworks become a genuine barrier to the technological development of mass vessels. As we have discussed so far, some of the concerns can be circumvented by interpreting wording more widely and making the current laws adapt to mass vessels rather than the other way round. To recap, the most significant barrier seemed to be Article 94b and its master requirements, which seem quite incompatible with totally autonomous ships. However, as previously mentioned, it seems Article 94.5 of UNCLOS may be the solution, affording states the ability to expand previous definitions to allow MAS to fit within the current frameworks. So, overall, MAS may not have hit a barrier yet in regards to UNCLOS and SOLAS, but time will tell to see if we end up with a sinking MAS on our hands.